Hello and welcome to Spardha Lines, your one-stop destination for civil services preparation, UPSC, KPSC and SSC. What we will try and understand is a couple of important articles from the daily current affairs discussion. We have taken very important articles which are very important from the GS paper 1, GS paper 2, GS paper 3 as well as all your optional papers with respect to political science, public administration, so on and so forth. The first important article that we have picked up is called as the sense of proportion from the Hindu. This is very important from two papers. One is with respect to your polity. The second is with respect to your governance. Let us try and understand what is this article in greater detail. What is the context here? We have the Supreme Court of India was looking into one of the issues, whether the conviction of Congress leader Rahul Gandhi has to be stayed or it should continue. Whether the conviction of Rahul Gandhi with respect to the defamation case, should it be continued or not? So what has the Supreme Court said? The Supreme Court in this particular case has stayed the conviction of Mr. Rahul Gandhi, has ultimately said that conviction will be stayed. Let us try and understand what is this article in greater detail. We will also try and understand the nuances of defamation. We will also go ahead and understand what this article speaks about when it comes to the parliamentary proceedings. What is the context? What was the background to this particular issue? What we have is the Congress leader Rahul Gandhi. What did he do? He was embroiled in a controversy over his "why all thieves share the Modi surname" remark dating back to a political rally at Karnataka's Kolar in 2019. What is this case all about? The case is with respect to defamation case. What did Mr. Rahul Gandhi say? Rahul Gandhi said that why all thieves share the Modi surname in one of the political rallies at Karnataka's Kolar in 2019. What do we understand by this? He was addressing to one of the political persons. But Modi as a surname is not just referred to one of the persons, but it is to a larger community as well. So when you look at Gujarat, you have number of people, large number of individuals who use this particular name Modi as the surname. So when you are addressing such sensitive statements, you should have had the responsibility, you should have had the sensitivity, is what the courts have said with respect to this particular issue. So ideally, what has happened here? A person with another name called as Modi has filed a defamation case saying that all those persons having Modi as the name, their names are embroiled into this particular controversy, and ultimately it is a case for defamation. So what is defamation? Where is it mentioned? What we have to look at is section 499 of the Indian Penal Code as well as 500 of the Indian Penal Code. So what is section 499 of the Indian Penal Code? What it refers to is called as the defamation. Whoever by words either spoken or intended to be read or by signs or by visible representation makes or publishes any imputation. What is this imputation? Imputation basically stands for what is called as the allegation. So I am making an allegation against another person. Let's say I as an individual am making an allegation against you, an accusation against you which may not be true, and that in the present sense may defame another person. His reputation could be at stake. So what am I bringing here? Am I bringing an accusation which may not be true according to that particular person? So if there is no truth in that particular accusation or in that allegation, this leads to what is called as 499, and immediately IPC section 499 will get pressed against the person who has made such derogatory statements. So any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said except in cases herein referred to that person. So what is explanation 1? It may amount to defamation to impute anything to a deceased person. Who is a deceased person? Any person who has passed away. Any person who has passed away. In case we are speaking against that particular person, and if it is going to hurt his reputation and his family's reputation and hurt the feelings of the community as well as his family and his friends, such could be falling under defamation. Then we have it may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. It is not just the individual, it can also be a company as well. Let's say for example we have a company A, or we have a company B, or let's say we have a company C. If there is a particular company which is conducting its activities, let's say A company, B company, C company, whatsoever, if a person is making an allegation against that company, that particular company may also sue the person who has conducted this particular accusation or an allegation. Explanation 3 says, an imputation in the form of alternative or expressed ironically may amount to defamation. What is this ironically? One, I am making the narrative directly. The other is where I am making a narrative implicitly as well. I am drawing a reference to a particular connotation and ultimately bringing it to that particular person's name or to that particular person's company. If an implicit assumption, explicit assumption, or a corollary is drawn, in that case what we have is this particular defamation coming into picture. No imputation is said to harm a person's reputation unless that imputation directly or indirectly is estimation of others, lowers the moral and intellectual character of that person, lowers the character of that person in respect of his caste or of his calling, or lowers the credit of that person, or causes it to believe that the body of that person is in a loathsome state or in a state generally considered as disgraceful. Only when such parameters fall into picture, defamation takes into picture. So ideally, when defamation has to be applied, when defamation has to be taken into consideration, it should put down the character of that particular person. His reputation could be at stake. That is what section 499 of the Indian Penal Code speaks with respect to defamation. So what would happen? Let's say I make an accusation, let's say there is an imputation. So if I am making an accusation against another person, if that person's reputation is at stake, he will file a case. This will go on with an investigation, and ultimately I, as a person who may have made this particular accusation, may come under the law books. So this is where we have section 500, which goes on to say the minute this particular person is making such a claim, what we will have is defamation punishment. So where is it defined? This is defined under 500 of the Indian Penal Code. So section 500 of the Indian Penal Code basically speaks about punishment for the defamation. What is it? When we speak about the punishment, a person will have a defamation issue and he will continue to be with it if it is with an imprisonment of 2 years or more. So it may extend to 2 years, or it may also go ahead with fine as well. It is in this particular backdrop that Mr. Rahul Gandhi was convicted. Let us try and understand the series of events in this particular case. So what exactly happened? So there was an individual who was hurt by the wordings of Mr. Rahul Gandhi, and ultimately he files a case in the trial court. So what happens? It goes to the trial court, and after the trial court, it immediately goes to the session court, and from the session court, it goes to the high court, and ultimately it goes to the Supreme Court of India. Our present context is we have the Supreme Court of India, which has looked into this particular issue and has stayed the conviction. So what exactly happens in the trial court? The trial court looks into this particular issue, and ultimately it goes on to say, yes, defamation has occurred to so and so person. So you have made a statement, and ultimately you have made a statement which is in derogatory with the defamation terms. So the person's reputation is at stake. You have called the entire Modi community as the thieves, says the court, and ultimately the person, that is Mr. Rahul Gandhi's case, was taken into consideration and a conviction of 2 years was imposed on him as per section 500 of the Indian Penal Code. This is where we have to go back to the year 2013. What happened in 2013? We have a landmark judgment that was delivered by the Supreme Court of India in Lily Thomas case. So remember, we have a landmark judgment in 2013 that was delivered by the Lily Thomas case. What exactly is this Lily Thomas case all about? We have one of the major laws that also governs the politicians as well as other areas when it comes to elections. What are we speaking about? We are speaking about the representation of the People's Act of 1951. We have this section called as section 8. What exactly happens in section 8 prior to 2013 and after the judgment of the Supreme Court? Let's say a person has committed an offense. Let's say I am a politician. I might have committed a heinous offense. Assume me as an MLA or as an MP. I'm not an MLA or an MP. I'm just an advocate teaching you all. But let's assume for a moment that I am an MLA or an MP. So what do I basically do? I have committed a heinous offense. So there is a trial court or the sessions court based on a particular crime that I have committed. I will be going to a sessions court or to the trial court, which can also be a magistrate as well. So the minute I go to the sessions court, what do? There are charges that are pressed against me, and ultimately these charges are proved in the court of law as well. And after it is proved in the court of law, what will the courts do? It will convict me. So when I am convicted, let's say I have committed a murder, or let's say I have committed a heinous offense as well. In that particular case, the court of law convicts me. So I will be thrown behind bars as well. So what do? I am not happy with this particular decision. So what do? I go and appeal in the High Court. Prior to 2013, that is prior to Lily Thomas case, what would happen if I am committed or if I am convicted by the trial court, that is the sessions court in this particular case? I have the provision where until I am convicted by the higher court, that is the High Court, or it can be the Supreme Court, I will not be suspended as an MLA or an MP. But after 2013 Lily Thomas case, what exactly happened? In case I am convicted in the trial court, I would be disqualified immediately as an MLA or MP. Prior to 2013, I was given the leverage, I was given the provision where I had the time to appeal as well. So we have the sessions court convicts me. So what do? I go to High Court, and in High Court it may take 1 year or 2 years, 3 years, 4 years, whatsoever it is. So for this 4-year period, I would not be disqualified as an MLA or as an MP. But after 2013 Lily Thomas case, what exactly happened? If the session courts convict me, immediately I am disqualified as an MP or an MLA. So in the present situation, we have the trial court which has convicted Mr. Rahul Gandhi, and it says that according to section 8, if there is an imprisonment period for more than 2 years, that particular person will be immediately disqualified as per Representation of the People's Act. So the 1951 Act provides that a person would be disqualified from their membership of either House of the Parliament or the State Legislative Assembly or Council if convicted and sentenced to imprisonment for 2 years or more, and shall continue to be disqualified for a further period of 6 years after their release. This is the significance of Lily Thomas case. So what happened in Rahul Gandhi's case? He was imposed with a conviction of 2 years and more. Since he was imposed with a conviction of 2 years or more, he immediately was disqualified as a member of the parliament. So we have the trial court which makes this particular conviction, but he was also given the liberty and bail to file a case in the higher court. He eventually goes on to the sessions court. He also goes on to the High Court as well. The sessions court and the High Court looked into this particular issue, and they went on to say that Mr. Rahul Gandhi should have been sensitive enough because he was addressing a larger community in the state of Gujarat. Now finally it goes to the Supreme Court of India. The Supreme Court of India looks into this particular issue. It makes a statement that yes, Mr. Rahul Gandhi may have committed a wrong. In this particular case, we are not going by the merits of the case, but what we are currently looking is to that particular area. What is that area of inference that we are drawing? This happens to be a non-cognizable case. There are two types of cases. One is what is called as cognizable offense. The other is what is called as non-cognizable offense. What is this non-cognizable offense? What is this cognizable offense? Let's say, for example, I am a person who's committed a murder. So this happens to be a cognizable offense, or there is a particular crime which is defined as cognizable offense. Where do I know whether this particular crime is a cognizable offense or a non-cognizable offense? What we have to refer is called as the Code of the Criminal Procedure. We have the Code of the Criminal Procedure, which is also called as the CRPC. We have Schedule 1 for all the offences that are present in the Indian Penal Code. You refer the same in the schedule of the CRPC. What you would have is reference to cognizable and the non-cognizable offences. For let's say if I have committed a murder, it is a cognizable offence, or let's say there is a thief who's committed a particular crime, it can be cognizable or non-cognizable depending on where it is placed in the Schedule 1. So in this particular case, the defamation happens to be a non-cognizable offence. So when it is a cognizable offence, the police officers would be directly able to arrest them without the permission from the magistrate, but if it is a non-cognizable offence, this will require the permission from the magistrate. So in this case, defamation, what we see, it is a non-cognizable offence. So what the Supreme Court says is that the conviction is stayed. It will not be implemented primarily because it is not a cognizable offence, but instead it is a non-cognizable offence. Had it been cognizable offence, the gravity of the offence would have been more as well, but in the present instance, since it is a non-cognizable offence, they take a reference that this person need not be convicted. They also further go on to say that if the conviction is upheld, there are two people who would be the major sufferers. Who are these two people? One who happens to be the appellant who's gone before the Supreme Court of India. He would lose his candidature and he would no more be the MP of Wayanad. So on one side, he as a person, as an appellant, would lose his position as an MP. So he is not just a person, he is an MP representing a certain section of the people. So if Wayanad people have elected him as the representation of that particular constituency, they will also suffer in this particular backdrop. So it is that person, the appellant, who will suffer. It is the representative. He has the capacity of a representative of Wayanad. He, that is the person, as well as his constituency members would suffer. So we stay this particular conviction, say the Supreme Court of India. So basically, in order to ensure that the representation of that constituency is represented, since it is a non-cognizable offence, we will continue to stay this particular issue. We are not declining for the fact that defamation case continues, but the conviction need not be present. So the 2 years are more, where it will lead to disqualification of an MP or an MLA or a council member. Each state, says the Supreme Court of India. This is where the article draws a comparison and says that it is now the onus and the responsibility of the Parliament to ensure that all these opposition points have to be taken into consideration. Mr. Rahul Gandhi should be allowed to participate in the debates and deliberations of the Parliament so that he can voice out the concerns of his constituency and as a member of the Indian National Congress. It is this that we have to understand. As part of the assignment, you have to put on the comment section, there is one of the articles in the Indian Constitution which basically speaks about the disqualification. Which is this article which speaks about the disqualification is what you have to put on the comment section. Now let's look into the next article. This article says the bureaucracy as prosecutor and judge. Let us try and understand what is this article in greater detail. This article speaks about the reference that have been made with respect to couple of issues when it comes to industries in India. What exactly happens? We have couple of industries in the country. We have organizations that empower people as well. They uplift the people. They also provide economic prosperity over a period of time. But there are couple of laws, rules and regulations which has created a lot of clutters within this organization. So what exactly happens? Let me give you one of the reiterations from the economic survey. We have the economic survey, let's say in 2016 or 17. It came up with a particular idea of Chakravyuha challenge. What is this Chakravyuha challenge? Basically, what you would have is a particular company. The company will start its process. Let's say it conducts its activities and ultimately at one fine day, it want to exit from the market. So what does exit mean? Exit basically means they do not want to conduct their activities anymore. They do not want to build about any of the structures anymore. They want to shut their operations and ultimately bring an organization to an end. But the economic survey back then said that this Chakravyuha challenge was a major impediment. Impediment how? That I would be able to start an industry or an organization, but shutting an industry had become a cumbersome process. It had become a very irrational process and it involved a lot of bureaucracy and red tape as well. And as a result, companies face a lot of issues. So the Chakravyuha challenge basically means that you are in a maze, you enter that particular maze, you are in that labyrinth, and when you want to exit, you do not know the ways and means to enter out of the system. So you enter the system, but you do not know how to exit the system. This is one such challenge for the industries and the organizations. Similarly, we also have couple of laws. These laws are irrational and illogical and have been in time for a very long period of time, and this is also acting as an obstruction and an impediment to such people. How? Let me give you an example. Let's say if I have to start off an industry, what do I want to do? I want to make profits, and at the same time I want to create economic prosperity for other people as well. So I am contributing to the country in terms of GDP. I am also growing, and I'm also giving job opportunities to the people. So there are these prescribed number of laws that are present in a country. I have to follow these laws. No doubt that I have to follow these laws. But what exactly happens while I'm following these laws? There are these honest mistakes that might happen. Generally, there are these mistakes that might be committed. If these mistakes are committed, what should ideally happen? These are civil in nature, so I should be imposed with a penalty. But what happens with the present laws? Instead of imposing the penalty, they are imposing criminal antecedents against me. They are throwing those people behind bars as well. So why would I want to enter and commit to an organization and a company? Even for an honest mistake, even for a small mistake that is committed, there are criminal penal provisions that are in place instead of fines. So what would happen? Companies are not entertained to open new offices because they are worried, they are scared what would happen and what are the criminal antecedents that will be put against me. And as a result, in order to overcome all these issues, so wherever required, yes, we will have the criminal provisions, but in other cases these criminal provisions will be replaced with fines. Is what is this Jan Vishwas Act of 2022. So this article basically speaks about the Jan Vishwas Act of 2022, which basically ensures that the criminal precedents and the provisions will be replaced by fines. Why did the government come up with this particular legislation? That is because currently there are 1536 laws which translate into around 70,000 compliances that govern doing business in India. These excessive compliances have proved onerous for business enterprises, especially MSMEs. A 2022 report by the Observer Researcher Foundation on imprisonment clauses in business laws revealed that among 69,233 unique compliances that regulate business in India, 26,134 have imprisonment clauses as a penalty for non-compliance. The ORF report added that an average enterprise in the manufacturing sector with more than 150 employees deals with 500 to 900 compliances a year that cost 12 to 18 lakh a year. All these statistics basically give out a picture that it is very tough for the organizations, companies to go ahead and perform these kind of activities. In order to overcome all these issues, they have come up with the Jan Vishwas Act. This Jan Vishwas Act basically has couple of important paradigms. What are those? One, it decriminalizes the offense. It removes all offenses and penalties under the Indian Post Office Act of 1898, changes grievance readdressal mechanisms and appointment of one or more adjudicating officers for determining penalties. These officers can conduct inquiries into violations of respective acts and even summon individuals for evidence. A periodic revision of fines and penalties for various offences in the specified acts. It proposes an increase of 10% of minimum amount every 3 years. So what this particular legislation will now do is, number of laws that are present in the picture, these laws which have criminal precedents, criminal provisions, will be replaced with fines. To adjudicate whether how much of fines should be imposed, what we will have is the adjudicating officers with respect to relevant laws. So this Jan Vishwas Act basically ensures that more organizations are in picture, more companies are providing services, more people are empowered, and ultimately there is economic prosperity. So they were once scared of the bureaucracy, the red tape, and all the criminal precedences that have been in place. These criminal precedents will be taken off, and what we will have is fines in this particular case. So this is with respect to this particular issue. So what are the advantages? The major advantages, whenever we speak of such cases, what would happen? There will be criminal charges that would be pressed against these individuals. So when criminal charges are pressed against these individuals, they will not be happy against it. So what do? They ultimately will head to the judiciary. So when they head to the judiciary, there is more litigation, there are more disputes in the court of law. When there are more disputes in the court of law, this leads to clogging in the Indian judiciary. We know for the fact that the Indian judiciary has a lot of cases in the Indian judiciary. There are crores of cases in the trial court, lakhs of cases in the high court, and there are 70,000 odd cases in the Supreme Court as well. So leading to more number of litigation, and ultimately companies would not want to invest. So with this particular provision that we have, where adjudicating officers will take care of it, the pendency of cases will reduce, more cases in litigation may not go to the judiciary, and ultimately it will prevent the issues of clogging of pendency of cases in the judiciary. Added to it, the criminal precedents will be removed. What we will have is fine, so the red tape will also be reduced over a period of time. These are the advantages when it comes to the Jan Vishwas Act. However, there are issues with respect to this particular issue as well. What is it? As of now, what we have is the adjudicating officer. This adjudicating officer is part of the executive. This is where the author brings into picture one of the interpretations. What is this interpretation? The author draws into picture what is called as the Article 50 of the Indian Constitution, which speaks about separation of powers. What is the separation of powers? We know for the fact that we have legislature, we also have executive, and we also have judiciary. When it comes to United States of America, what we have is clear-cut separation of powers between legislature, executive, and judiciary. But in India, what we have is Article 50, which goes on to say that there is separation of powers only between executive and judiciary. Have you ever wondered why legislature is not included? That is primarily because when it comes to India, what we have is the overlapping jurisdiction. What is this overlapping jurisdiction? The legislature, that is the MLAs and the MP, first, if I have to become part of the executive, that is as part of the cabinet and the government, what should I do? I should first become the legislature. Only after I become the legislature, that is when I'll be able to go on to become a cabinet member. It can be the finance minister, it can be the home minister, or it can be the prime minister. So in India, the legislature go on to become the executive, and ultimately that is why Article 50 goes on to say separation of powers between executive and judiciary. But when it comes to United States of America, the legislature is not part of the executive. It is the Congress which makes the laws. It is the Joe Biden's executive which will implement the laws, and ultimately judiciary which interprets the laws as well. There is strict separation of powers when it comes to United States of America in the form of legislature, executive, and judiciary. But when it comes to India, we do not have the strict separation of powers. So it basically means the legislature go on to become the executive, and ultimately there is separation of powers between executive and judiciary. So the author in this particular case go on to say what we have seen in the past few years is increase of the tribunalization. What is tribunalization? Which basically means there are more number of tribunals that are present. When there are tribunals, what you will also have is the technical members. Who are these technical members? The retired bureaucrats. You will have the retired bureaucrats who have subject matter expertise, who will be present in that particular tribunal as an administrative head, and at the same time you also have couple of other institutions like the SEBI, Securities and Exchange Board of India, the Competition Commission of India. You have many other tribunals and acts as well. For example, the Prevention of the Money Laundering Act, the Information Technology Act, Food Safety and Standards Act of 2006, All these acts basically will have an administrative member, which means he is part of the executive. This is where the author draws a reference. The author goes on to say that this is the responsibility of the judiciary. How? Let's say, for example, there is an issue. It is the judiciary which has the judicial mind to apply the discretion. It checks the previous precedents. It also learns the honest mistakes. It also looks into the aggravating and the mitigating circumstances. So it knows for the fact how to apply a particular law. It also takes into picture other circumstances and evidential proof as well. So only the judiciary is capable of interpreting the law and ultimately putting a penalty on a person. But if you are giving so much of power to the bureaucracy, to the red tape, they may not serve justice, says this article. Basically, if there is a law, this law has to be interpreted, and this law will be interpreted by the judiciary, and ultimately a penalty would be imposed. This is the right that is given to the judiciary. They are the ones who interpret the laws. The laws may have been made by the legislature, but who interprets the laws? It is the judiciary. And how do they impose a penalty? Based on the facts and circumstances of the case. But when this power is snatched away by the executive, who are administrative technical members, this separation of powers get violated, and that is what this Jan Vishwas 2022 is promoting, says this article. Added to it, there are other major concerns as well. What are these concerns? Let's say, for example, we have Air Pollution Prevention Act. In this particular case, what would happen? There has to be some deterrence for the industries or for any individual that they should not be committing such an offense. For example, polluting the air, we all inhale air, but if that particular area has a lot of pollution, air pollution, what we will be breathing is a toxic air. In order to act as a deterrent, some penal provisions in the form of criminal precedents should be there. But what has happened in the Jan Vishwas Act? What you are trying to do is liberalization, where there will be only penal provisions in terms of penalty and not criminal precedents for huge companies which are engaged in constant money grabbing. For them, money is not a matter. They may create environmental consequences. This ultimately could be a problem, says this article. So this article basically goes on to say that yes, we do have advantages, but certain issues like separation of powers and deterrence should further continue, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, is India's sugar surplus leading to a crisis? Let us try and understand what is this article in greater detail. Let me give you a gist of this article. What exactly is happening? When we look into the data, we have India, which is currently one of the largest producers of sugar. In fact, data also go on to say that we have even surpassed Brazil as well. So what does India do? India has excess sugar. So apart from the domestic consumption, we are the largest domestic consumers. India is one of the largest consumer of sugar. So what do? We have enough for domestic consumption. After India has had enough for the domestic consumption, we start exporting sugar to another country. So the minute we start exporting sugar, we have to draw a relevance of it. What is the relevance? One, the central government is providing a lot of subsidies. The state governments are also providing subsidies as well. Central government is providing subsidies, so everyone is wanting to enter to this particular area. It is providing fair and remunerative prices. When fair and remunerative prices are given to sugar, most of the farmers will only want to grow sugar as well. They will not look at other crops, and as a result, the other crops are the major suffering points. So people would want other crops as well. People would want other food items and grains as well. But what is the problem here? Since fair and remunerative prices are given by the central government to sugar, most of them are using only sugar at the cost of other food grains and crops. So this could lead to problems where we may have to import other set of crops, is the first argument. The second argument basically goes on to say that we have the state governments. The state governments also give other additional remunerative prices for the sugar industry. This again is in the backdrop of politics in place. This is because of the freebie culture that has been promoted by a couple of states in India. So in order for the political gains, Rather than looking at the larger prospects, what we have is this particular limited scope, a narrow myopic view, which is ultimately destroying other crops because of the state governments. The third point that we have to focus is with respect to the water crisis. What exactly happens when it comes to the sugar? What we have to look into is sugar regularly requires about 3000 mm of rainfall, and at the same time it will also require 1000 to 1200 mm, relying heavily on the groundwater. So India relies on the monsoon, and for the rest of the other parts of the country, what we rely is on groundwater. What we are exporting right now is not just sugar, we are also exporting water indirectly as well. India already does not have enough of water. We are extracting a lot of groundwater as well. So when we extract groundwater for sugar, what are we making use of? Groundwater for sugar, and we are exporting this sugar to couple of countries world over. So when I'm exporting, it is not sugar that I'm exporting, but it indirectly means I'm also exporting water. India is a water deficit country, so indirectly we are the major sufferers, not only exporting sugar, but we are also exporting groundwater. In order to make sure that there are a couple of issues that we address, the government has come up with number of schemes and programs in order to prevent the export of sugar. In order to deal with sugar surplus, the Indian government has considered diverting it to the production of ethanol, an organic compound made by fermenting sugarcane molasses or sugar. This is one such step that the government of India has taken. Added to it, while the environmental implications of sugar production should be clear, surplus production and export have enormous financial gain, but there is also issue as well. So we have to correct these incentives. So basically, apart from sugar, what we have to do is provide subsidy schemes for various other programs as well. We have to be complementing it with environmentally responsible sugarcane cultivation, for which we can make use of drip irrigation to tackle this particular issue. Added to it, we can make use of cleaner practices like rainwater harvesting, wastewater treatment, canal irrigation networks. This will minimize the stress on groundwater reservoirs as other water reservoirs become available for irrigation, says this article. Now let's look into the next article. This article here is speaking about Financial Action Task Force. This is very important from the preliminary examination point of view. All that you have to do is remember a few important facts. The Financial Action Task Force is an intergovernmental organization. When was it founded? It was in 1989. This could be very important from the UPSC Civil Services examination point of view, as well as for the factual information to the state services as well, especially if you are writing any of the state services like the KPSC. And with respect to UPSC as well, remember it is an initiative of the G7 to develop policies to combat money laundering as well as certain interest as well. So one, it was started in 1989 basically to prevent money laundering, and this is an initiative of G7. In 2001, its mandate was expanded to include terrorism and financing. The objectives of FATF are to set standards and promote effective implementation of legal, regulatory, operational measures of basically combating money laundering, terrorist financing. When it comes to FATF, there are two types of lists. One is what is called as Financial Action Task Force Blacklist. The other is the Grey List. What is this blacklist? These are the countries which do not have any rules, regulations, laws, nothing whatsoever, and they do not follow the rules that are prescribed by the Financial Action Task Force. So if there is a country which has been asked to monitor money laundering issues, which has been asked to monitor financing terrorism issues, they have to basically have a law which is domestically present to prevent money laundering and prevent the financial action activities towards the terrorism. But if there is a country which has no laws whatsoever, they are not ready to cooperate with this financial action force, that particular country will be placed under the blacklist. As part of the assignment, you have to put on the comment section which are those countries which are present in the FATF blacklist. Please put it on the comment section. What is this grey list? Grey list basically says that there are these countries which have the laws, but they are not able to meet up to the standards of the Financial Action Task Force. There are laws, rules and regulations that have been put in place, but despite these rules and regulations that exist, they are still not able to meet up to the standards as established by the Financial Action Task Force. So such countries will be placed placed under grey list. Pakistan was in the Financial Action Task Force's grey list. It comes and keeps going in the grey list as well. Why? Because they have been supporting few terrorist organizations. So basically, if there are laws but these do not meet up to the standards as envisaged by the Financial Action Task Force, in that case they'll be placed under grey list. If there are no laws, they're not ready to cooperate, those countries will be placed under blacklist. Now let's look into the next article. This article says that the Prime Minister Narendra Modi ji has revamped 508 Amrit Bharat stations. So what is the context? This article here is basically speaking about the program that has been envisaged by the Government of India, and that is with respect to Amrit Bharat stations. What is the aim of it? It enhances facility beyond the minimum essential amenities. It is aimed at construction of roof plazas and city centers at the station. It caters for the introduction of new amenities as well as upgradation and replacement of existing amenities in the railway stations. So the Government of India has been taking a couple of initiatives, for example building up the infrastructure to prevent accidents as well in line with the railway infrastructure. What they are currently ensuring is to upscale the infrastructure in the railway stations. This will basically ensure that there are stations built for entry and exit, circulating areas, waiting halls, toilets, lift and escalators, cleanliness, free Wi-Fi, kiosks for local products, information system, executive lounges, nominated spaces as well as landscaping. These are some of the areas which will be improvised over a period of time when it comes to the railway stations. These are some of the important topics from the Hindu today, and all that you have to do is watch these news analysis. And apart from this, we will also come up with some of the important issues in news, where we will discuss some of the issues which have a larger imprint to the society. So if you have liked these initiatives, please do like, subscribe to our YouTube channel, share it with your fellow aspirants, and please throw some light on the comment section as well. So that's it for today. Thank you for watching.